Imagine creating a revolutionary new drink that could take the beverage industry by storm. How do you protect your unique formula from competitors? Today we're exploring whether you can patent a beverage formula, the key steps involved, and alternative protection methods. Patents are government-granted rights that allow inventors to exclude others from making, using, or selling their invention for a limited time. For beverage formulas, a utility patent is typically required. This type of patent covers new and useful processes, compositions of matter, or manufacturing methods. To be eligible for a patent, your beverage formula must meet several criteria. It must be novel, meaning it's different from all previous inventions in its field. It should be non-obvious, which means the formula wouldn't be immediately apparent to an expert in mixology. Finally, it must have a useful purpose. Before applying for a patent, it's crucial to conduct a thorough patent search. This involves checking both issued patents and pending applications through the United States Patent and Trademark Office website. This step helps ensure your formula isn't too similar to existing patents, which would lead to rejection. If your search doesn't reveal any similar drink recipes, you can proceed with the application process. This involves obtaining a digital certificate and customer number from the USPTO's Electronic Business Center. You'll need to provide a detailed description of your drink recipe, including ingredients, preparation methods, and any unique processes involved. The cost of patenting a beverage formula can be substantial. As of the latest fee schedule, the basic filing fee for a utility patent application is $630. Additional fees apply for extra claims, examination, and issuance of the patent. Legal fees for a patent attorney can range from $5,000 to $15,000, depending on the complexity of your application. For those planning to sell their beverage internationally, it's important to consider global patent protection. A U.S. patent only protects your formula within the United States. To secure international protection, you might file a patent cooperation treaty application or apply for individual country patents. This process can be complex and may require the assistance of an intellectual property attorney specializing in international patents. While patents offer strong protection, they're not always the best option for beverage formulas. Alternative protection methods include trade secrets, which involve keeping your formula confidential, similar to how Coca-Cola protects its recipe. Trademarks can protect your drink's name, logo, and branding elements. Copyrights may cover marketing materials and packaging designs. In conclusion, patenting a beverage formula is possible, but comes with specific requirements and significant costs. It's essential to weigh the benefits of patent protection against alternatives like trade secrets or trademarks. Consider your long-term business strategy, the uniqueness of your formula, and your plans for international expansion when deciding how best to protect your beverage innovation.